To you, our speaker host, John Seaton, to introduce the Honourable Bruce Debelle. Thank you very much.
Rotarians, it's my great pleasure to introduce to you Bruce Debelle. Bruce graduated from Adelaide with an honours degree in law in 1960. He was then a Judge's Associate to Sir Victor Windeyer, Justice of the High Court of Australia. And leaving out a lot of his CV, I then moved to when he was appointed Commissioner of the Australian Law Reform Commission when he worked with Justice Michael Kirby. And 3 years later he returned to Adelaide. He was made a Queen's Counsel and he still practices from bar chambers. He was made President of the Law Society from 1989 to 1990, and he also served the national legal profession as a member of the Executive of the Law Council of Australia. He was President-elect of the Law Council on his appointment as Justice of the Supreme Court of South Australia in October 1990. He served as a Justice of the Supreme Court until he retired on his 70th birthday in 2008, and he then became an acting Justice of the Supreme Court in New South Wales for 2 years, and he served as acting Justice of the Supreme Court from 2008 and is still holding that office. He served on the executive of the Judicial Conference of Australia, the National Trade Union for Judges, from 2002 until 2008, and was later chairman. He was made an officer of the Order of Australia in 2010. He's married to Pam. They have 5 children, and they have 12 grandchildren, all of whom are very proud of their grandfather. Bruce.
Thank you, John, for that very kind and generous welcome. The last lines were a change in what I said. I had said that I was inordinately proud of my grandchildren. It doesn't mean that the reverse necessarily applies. I congratulate Nick Handley for bringing as his guest David Bleby, who was a colleague of mine when we served together for a number of years on the Supreme Court. Ladies and gentlemen, it's always a good idea when you have one judge speaking to you to make sure that there's another judge also present. It's a bit like a court of appeal. They can keep each other in check, do you see? 2015 has had 3 great anniversaries. It's the 800th anniversary of Magna Carta. It's the 200th anniversary of the Battle of Waterloo. And on August 15th, we celebrated the 70th anniversary of the end of World War II. And you look at me and puzzling, what's this fool on about? What do those things have in common? There is, in fact, a common thread, ladies and gentlemen. It is freedom. Magna Carta, a much heralded and perhaps overstated protector of freedoms, but it has been the source of many freedoms since. And of course those two, the Battle of Waterloo was the end of a battle against a dictator, Napoleon. Wars have been fought over some 15 years. And of course World War II was our fight for freedom against other nations. So let me therefore talk to you about freedom under the law and how it is we maintain the rule of law in this country. What do I mean when I talk about freedom under the law? Freedom under the law means we're free to do whatever we like, subject to proper legal constraint. So we can say what we like, subject, of course, to the law of defamation and laws that prevent sedition. But what is it that enables us to enjoy that freedom under the law? It is because we live in a country where the rule of law exists. And what we mean by the rule of law. When we use the expression, the rule of law, we mean the supremacy of the law. That is to say, that the law prevails over each individual citizen, no matter how high or low in status that citizen might be. In other words, we have equality before the law. No person is above the law. The Prime Minister and the Governor-General are just as subject to the law's restraints as the lowest citizen in the land. Equally, Royal Commissioners are subject to that law. And of course, as we know, it's a question of watch this space so far as Commissioner Hayden is concerned. And I'm happy to speak about that later if you like. But more importantly, so are governments subject to the law. And that proposition that governments are subject to the law is a very striking proposition to others in Asia and countries in Eastern Europe and in parts of Africa where dictators rule and their will, if not their whim, is the law. Two other important aspects of the rule of law must be noted. The first is that the rule of law has the notion that we are free from the exercise of arbitrary power by government. Again, I repeat it, it's the supremacy of the law. Governments cannot act arbitrarily. History is replete with examples of individuals cast into prison at the whim of a monarch or dictator. But in our system, it is the rule of law that prevents that knock on the door in the middle of the night and a person being spirited away, never to be seen again. We are, in fact, free from arbitrary arrest by police or any government official. Another important aspect of the rule of law is that our legal system has the means to prevent breaches of the law. Adequate remedies are available to the citizen to enforce the law. In short, the rule of law means the supremacy of the law over every member of the community. Now, we know that the rule of law applies in Australia, but it doesn't apply in other countries. Why is that so? Let's take, for example, Zimbabwe. It inherited the same common law system from England that we inherited in this country. But you could not think of a greater contrast between one country that enforces the rule of law and another that does not. Now, ladies and gentlemen, some might tell you that the rule of law is preserved by guarantees in a constitution. That is not so. Let me give you an example of words from the Constitution of one of the great powers in this world. Its Constitution reads, "The individual and his rights and freedoms are the supreme value. Recognition, observance and protection of human civil rights and freedoms is the obligation of the state." Wonderful, high-sounding words. Which constitution do you think it is? Or which country's constitution do you think it is? Let me go on. That constitution goes on to protect human rights in the clearest terms. Article 125 of the Constitution reads, "In conformity with the interests of the working people and in order to protect the socialist system," there's a clue, "the citizens are guaranteed by law, A, freedom of speech, B, freedom of the press, C, freedom of assembly, D, freedom of street processions and other demonstrations. Does anybody have a clue as to which constitution that is? Well done. It is the 1936... You've got one intelligent member of this club. The words I've been quoting were actually from the 1936 Constitution of the USSR. There is, in fact, a later 1971 Constitution, which is in slightly different terms. But the point can be made. How would those who suffered under the dictatorship of Joseph Stalin, what would they say about their ability to enforce their human rights? Imagine what Alexander Solzhenitsyn would have said. And we do know what he said, because his views filled the pages of the Gulag Archipelago and his other great work, The First Circle. So I come back to that question. Judges have a habit of repeating themselves. So I come back to that question that I asked a while ago. What is it that enables us to enjoy the rule of law in this country in a way quite different from other countries? The answer lies, ladies and gentlemen, in the independence of the judiciary. For many years in England, judges were appointed by the monarch. If your decisions pleased the monarch, you could remain in office, and there was a fair chance you might be paid, although it wasn't always sure that you would be. In 1689, in the glorious revolution of 1689, when William and Mary were appointed to the throne of England and the Stuarts were expelled from England, Parliament enacted a means whereby judges were given security of tenure. Judges remained appointed in those days for life, and you could not be removed from office unless there was proven misbehaviour, and that had to be carried by a joint resolution of both of the Houses of Parliament. That tradition was a result of the long wars against the Stuart monarchs, fought by the Crown and fought by the courts and the Parliament against rulers who thought they had absolute power. And the Parliament and the courts prevailed. That guarantee of the independence of the judiciary is now enshrined in the Federal Constitution. Judges remain in office whilst they're of good behaviour, that is to say, unless there has been proven misconduct or proven incapacity to hold the office, and that must be carried by a joint resolution, as I say, of both of the Houses of the Parliament. In South Australia, we have a similar provision, although it is not as strong as the Commonwealth provision. And so in Australia, judges are able to rule upon the validity of actions of government. They can rule on the validity of the actions of police. They can rule on the actions of royal commissioners if royal commissioners believe they should go on when they should not. Judges are subject also. Judges can be can be disqualified from considering a case if there is bias, and you've been reading a lot about bias, and it's not actual bias, it's only the perception of bias. And so we have challenges by citizens of governmental action at all levels. You may remember those two splendid gentlemen, ladies and gentlemen, Mr. Willing and the later Mr. Howie. They seemed to make it their crusade in life to incur a parking fine, always an Adelaide City Council parking fine, and then challenge the bylaw under which that fine had been imposed. And for quite a time they were successful, but not always so. At the state level, you can have challenges to governmental action. Permit me to boast for a moment, but I was on a court which had to decide, there were three of us, whether the laws which imposed Sunday trading some years ago were valid. It had been made by a proclamation. That proclamation was challenged by the Shop Distributive and Allied Trades Union, the Shop Assistants Union. And two members of the court said it was valid, I said it was not. The High Court agreed with me. There's my boast. But why? But how was that decision made? It was not made on whether I had religious views about trading on Sunday. It was not made because of any other view I might hold about Sunday trading. It was made by reference to the laws which the Parliament itself had passed, which directed how that proclamation should be made. So it's not a question of individual views, it's a question of applying the law. And you're all familiar with with challenges to federal legislation from time to time. The judicial independence then, ladies and gentlemen, not bills of rights, are critical to our democratic system of government. Alfred Deakin, who was a great founding father of the Commonwealth as well as a federal Attorney General and was himself 3 times Prime Minister, described the power of the High Court to interpret and act as guardian of the Constitution as the keystone of the federal arch. So I return to my question, the question that I asked at the beginning. Why are we able to enjoy the rule of law in this country, and why are we free from arbitrary arrest or detention? It is because the rule of law is maintained both by vigilant citizens and by an independent judiciary. Long may it be so.
Bruce, thank you so much. That was the most memorable address. And Rotarians and guests, it's a privilege to be reminded occasionally of the fundamentals of our culture, which can be lost in the early burly of life every now and again. But a talk like that just brings us back to what makes this society tick, and long may it last. There's time for a couple of questions. Do I have a question? Steve, as the intelligent one of the audience.
Thanks very much. It's great to be reminded of who we are and why we're in that situation. One of the nerve endings of this sort of issue is the concept of ICACs and holding governments or anybody or its agents to account. My sense is that we're going to see a dilution of that, and I use New South Wales, my home state, as an example. It just seems that all the wind has come out of the sails of that institution. Would you like to pass comment on that, or is it a bit too close to home? Your observation as a professional.
People have mixed views about organisations like ICAC, and there's a question whether ICAC should conduct its proceedings in public as they do in New South Wales, or in private as they do here in South Australia with Justice Lander, who is the chair of ICAC now. I'm not sure that the wind is going out of the sails of ICAC. Certainly ICAC has taken a couple of hits from the High Court, but the legislation is being amended, and my belief is that it should continue. One thing as a South Australian going to work, as I did with the Law Reform Commission for 3 years in 1978, was going from this state to Sydney, and then I really knew what the expression Tammany Hall meant. So I think it still applies, and there are those who say they must be obeyed, but I think the wind is still well and truly in the ICAC sails in New South Wales as I perceive it. Any other question? The Fitzgerald Royal Commission?
Yeah, the Queensland.
Queensland Fitzgerald, yeah.
Just said everything was
Well, I mean, if you're talking about ICAC in one breath and the Fitzgerald Royal Commission in another, both dealing with very similar kinds of conduct, political corruption at all levels, and I thought that the Fitzgerald Commission was a breath of fresh air and exposed what had to be exposed. David Seaton had a question.
Yes, thanks, Bruce. The presumption of innocence, presumably, is one of the fundamental elements of the rule of law. And in this country, we are presumed to be innocent rather than found guilty first. In other countries, I presume in America, you're guilty.
No, it well and truly applies in the States. Yeah.
Can you connect the two ideas of the presumption of innocence and the rule of law?
Well, it's not necessarily a part of the rule of law. There are countries where the rule of law prevails and the presumption of innocence doesn't. But generally speaking, in countries which have the rule of law, it does prevail. To me, it's an important question. It means that the guilt has to be proved. There's no presumption otherwise. And that's just a fundamental tenet of our whole system. It may mean, occasionally, the cynic may say, it may mean that a guilty person might escape. I'd prefer that alternative, I think, to people being wrongly convicted. And there have been cases of wrongful conviction. Yes.
Sir, we often hear that the law is an ass. I've often
In that case, I must have been braying for too long.
when you're sitting on the bench and you have the law on one hand, but common sense. Do you ever weigh up common sense with the law and make decisions on common sense sometimes?
Can I answer that question very easily? I was lucky to have Sam Jacobs, who some of you will know and remember, as my principal when I was an article clerk. And he used to repeat to me words which had been given to him by Sir George Lidgerwood. If you've had a look at the law and the answer doesn't make common sense, then go and have another look at the law. And that, I think, is the answer to your question. Judges do, in fact, make sure their questions are consistent with common sense. Howard Schultz. I'll just do with the Royal Commission too, if I can. I had to cut my speech short, but one of the things I was going to say, to me, a very important factor of maintaining the independence of the judiciary, ensuring that the right people are appointed. That's a topic for another talk. It really is. I've got strong views on that, and quite frankly, there have been occasions when incompetent people have been appointed.
I think we're probably just about...
Can I just say one thing about the Dyson Hayden's Royal Commission? I think it's a lot of fuss about nothing. David Bleby might have another view, but in my view, it is a lot of fuss about nothing, because Royal Commissioners are not judges. When a judge, particularly in a civil case, decides your rights, he tells you you've got to pay $1 million. He tells you that you've won against that person. It directly affects your rights. Royal Commissioners' decisions do not directly affect rights. They make recommendations. What has Dyson Hayden been doing so far? In his first report, he made recommendations for prosecutions. But some of those prosecutions are on foot. The persons who are the subject of those prosecutions, their rights will be affected once the criminal trial has occurred, not by anything that Dyson Hayden has done. It is important that there be an absence of a perception of bias, and it would be ideal if that was so, but we don't necessarily always live in an ideal world. And I think because his decisions do not directly affect rights, In the same way as a judge's decisions do, the test is therefore not quite so stringent. As I say, others might disagree, and even he himself might disagree. But there's my two penneth on the subject. Thank you for your indulgence.
Thank you, Bruce. There may be other questions. Richard, I'm sorry you didn't get a chance, but if you want to ask or discuss something with Bruce afterwards, he'll be here for a little while. Bruce, just in case you are still writing your judgments in longhand, I'm going to present a little token of our gratitude and respect.